We're here on this deeply emotional case. A life was lost, and nothing can diminish the sorrow of that fact.
So we are on the record in case A44652, Echevarria versus Zaon Collins and Marvin Collins. We are outside the presence of the jury. Someone said they want to make a record, so go ahead.
Judge, I believe you wanted to us to wait until now before defense does the for us to state our objections to their PowerPoint.
Yes,
Okay.
please.
And you have a copy of the defense PowerPoint there, Judge?
I do.
So I'm looking at page 8, or I guess slide 8. It looks like you have a multiple slides per page of everything.
Okay.
And we want to start there. So first and foremost, this statement that the toxicology report was flawed. So my understanding is that what they're alleging here is that the toxicology report prepared by Las Vegas Metro's forensic lab, which shows the quantitative results of Mr. Collins' post-crash blood draw, that it is flawed in some capacity. Judge, there is no evidence in this lawsuit that this tox report is incorrect or invalid or otherwise flawed in any manner. There's nothing in evidence or pre-admitted or not in evidence. There's no chain of custody concerns or contamination concerns. The defense did not hire a toxicology expert. So it's not coming from an expert. They didn't depose our toxicology expert. They didn't depose the Metro lab techs who facilitated or processed the blood draw and generated these results. So my understanding is that, and Ms. Zinna can correct me when it's her turn to speak if needed, that the defense is going to essentially justify this by claiming that, well, Zaon himself was part of this testing. It's his blood, and he's going to deny that he was impaired. So that gives them a viable basis to claim that that Metro's tox report is flawed. First, he's not qualified to make that assessment. So his opinion is irrelevant. They really have no one who actually is qualified to suggest that these numbers are flawed. And the characterization of this tox report is flawed. It's highly prejudicial. It insinuates that the figures themselves for the THC and the marijuana metabolite in terms of nanograms per milliliter are false figures, when there's literally no evidence whatsoever to support that. Our second objection, it's similar in nature. If you want to hear them all together, I can.
Okay. Your first part of the go ahead. Do you want to respond to the first part?
Yeah, sure, Honor. So plaintiffs bear the burden of proof in any civil litigation. I have no obligation to hire an expert. I am entitled to cross-examine their expert, and this particular expert that they hired, Raymond Kelly, was the expert that testified at the grand jury to interpret the toxicology.
Hold on. Are you going to say evidence will show the toxicology report was flawed?
Yes.
Okay. The objection's overruled. You are allowed to say this in opening if that's what you believe the evidence is going to show. The argument you're making right now, or the objection you're raising, this is for if she puts it in her closing argument, you can say evidence doesn't support this. Okay.
Okay. To make a record, Judge,
we're not, look, when you put something in opening, you're saying, and just like you guys did, our evidence is going to prove, or we're going to be able to prove to you, or evidence is going to show this is what the trial is going to come out. And they're allowed to say evidence is going to show the toxicology report was flawed, and you're allowed to say in closing why they're not correct there if they want to say that.
Fair enough, Judge. My understanding was that they have to have a good faith basis to believe that whatever they're referring to here will be admissible evidence and will be part of the trial record. And in our view, there's never been any evidence or even effort to invalidate the results of Metro's tox report.
Okay, you believe you have an expert that's going to say something that supports this, right?
I do not have a toxicology expert. I'm going to cross-examine their expert.
And they did not,
Did you depose their expert?
No, but I have his grand jury testimony. So I've already seen what he has to say about these toxicology reports.
Okay, and there's something in there
Yes.
that you believe supports an argument or you believe supports the statement here and that says the toxicology report was flawed.
Yes, I do. However, in light of the concerns raised, I am changing the language just a little bit, and I just handed my tech a note. I will
Okay.
change the language to be a little less, I won't use the word flawed.
okay.
Okay,
that-
do you want to tell them what word you are using?
The new word?
I don't remember what I wrote down. Did not provide a basis for a DUI charge.
Okay, so you're gonna say evidence is gonna show the toxicology report does not provide a basis for a DUI charge.
Correct.
Okay, do you still have the same objection?
Yes,
And
Your
you
Honor.
did disclose the transcript, right?
Yes, it is an exhibit 35. It's just not created.
Okay,
The objection, Your Honor, is charges are intermissible. It's convictions and guilty pleas that are admissible. So it doesn't matter if it provided a basis for a charge or not.
okay, well. You're gonna be able to say that later, okay? I'm gonna allow her to say toxicology or to put this in her, I don't know what argument's gonna come with this, or I shouldn't say argument, I don't know what statements are gonna come around it, but if this wording is being changed to toxicology report does not support a DUI charge, did not support a DUI charge?
Yes, the grand jury failed to return an indictment on the DUI charge.
Okay. Okay, you can say that. Toxicology report did not support a DUI charge. If you have grand jury transcript that supports that.
I do. Thank you.
Okay. Okay, next part.
On the next page, Your Honor, page 9 or slide 9, it's in similar vein. My understanding is that the previous objection was to the allegation that the Metro tox report was flawed, whereas what we have here is an allegation that that Dr. Kelly's report is flawed. But they say here that the grand jury did not find it viable to indict Zaon with a charge for driving under the influence. As Mr. Ladah said, we do not feel that the charges are relevant or admissible, but more so the grand jury's process of deciding whether or not to pursue charges. While those papers are part of an exhibit, they're not pre-admitted, they're not stipulated to as to authenticity, foundation, or relevance. We don't know, they have no way to get these in, Judge. They're not going to get them in through Dr. Kelly when we're talking about the decision-making process of the grand jury as to why they did or did not choose to pursue a particular indictment. Dr. Kelly did provide a report, but he's not part of the actual grand jury that makes the decision of whether or not to pursue an indictment.
Who testified in front of the grand jury?
He did, but he doesn't have a vote one way or the other as to whether they're going to pursue the indictment or not.
But I'm assuming she's using statements that he said in front of the grand jury. Yes, that's what you're gonna use to support this, your statement that evidence will show.
Yes, Dr. Kelly not only testified in front of the grand jury, but also Zaon Collins himself would be knowledgeable about the grand jury indictments that were returned against him, considering they were against him.
Okay,
I mean, if at a minimum, Judge, we would think that the grand jury did not find it viable. The did not find it viable is we're suggesting that the jury is going to see evidence that allows them to, step into the shoes of the grand jurors in terms of their decision-making process. I suppose if Your Honor's inclined to overrule the objection, we would at least ask for something simplified that the grand jury did not indict. I mean, we feel that the entire thing should be removed, but the suggestion that there was a lack of viability and that was the justification for not returning the indictment is making an assumption that's not part of the record. It's not in evidence, and we don't think they can get any evidence.
okay, so you want this statement to say the grand jury did not indict Zaon with a charge for driving under the influence, right?
I mean, plaintiff feels the entire bullet point should be removed, Judge, but in the alternative,
Is it not going to come in a trial that the grand jury didn't indict Zaon with a charge for driving under the influence?
I don't see why it would, Your Honor, quite frankly, because our position is charges are inadmissible, convictions are what it's admissible. So the convictions have come in via stipulation, they also come in through statute on a criminal conviction, on a car crash case involving this. But a charge, whether or not what the DA decides to do as far as charges, that's irrelevant completely. The DA can go through whatever process they want to decide whether to charge someone. Someone can do something wrong, and then the DA can decide not to charge them for whatever reason.
Yeah, but charges are not admissible generally because they're overly prejudicial to the person they were brought against. And it's usually the person they were brought against that's moving to keep them out. This situation, you're moving to keep them out, the charges? You want all the
Not
charges out?
convictions. The convictions have come in, but
I mean, if they open up the door with the charges, I mean, you get to ask about the charges then too. You don't want them to bring in any of the charges?
It's the absence of charges,
it's the
Judge.
absence of charge. He wasn't charged with DUI. The grand jury didn't indict for the DUI. That's the problem. And it's a
Okay.
different standard in a criminal case than a civil case. That's why
Yeah.
it shouldn't come in because
We
it's,
can have an instruction on that if you don't already have one included.
Right.
I mean, if this comes up, Your Honor, we are going to request such an instruction.
Okay.
So, I mean, I want to give this to I don't want to belabor this too much. That's
Yeah.
our argument is it's prejudicial. It shouldn't come in at all. But if it does come in, we ask for a specific instruction talking about the difference.
Well, I mean, I don't think juries have a trouble understanding that. I mean, we have a very famous case that I think we're all very aware of, where jury made it very clear they understand the difference between civil and criminal standards and civil and criminal burdens. Otherwise, like I said, there's a very famous case that I'm sure everybody knows what I'm talking about when I say that, where juries made it really clear that just because you're not convicted in a criminal case doesn't mean you can't get a pretty hefty judgment against you in a civil case. I thought we did go into that with the jurors where we asked them, do you understand? And I know we had some issues with the selection at that time, but I thought we did ask them, do you understand and will you be able to follow the instruction a judge gives you? We had very few with criminal experience too, if I recall correctly.
It's correct, Your Honor, but I wasn't able to, because of defense objections, I wasn't able to go into details on what the criminal standard is and what the civil standard is. So if this somehow comes in, we're going to request that the jury be instructed at the end that what the criminal standard is and that it's very different than the civil standard.
Yeah, I don't think there's a problem if this comes in, that we have an instruction on that if you don't already have one.
Your Honor, if he had been charged and he went to trial, for whatever reason, he was not convicted, we would not be able to get the fact that he was charged into evidence.
No, you wouldn't. I agree with you.
So the fact that there is an absence of charges inversely should not be able to be used as a sword by the defense when we would not be able to do the same in the inverse situation, Judge.
Okay. Do you guys want to respond to that at all?
Yes, Your Honor, I do. Okay, so first and foremost, the statute governing the admissibility of criminal evidence actually is for a very specific purpose. And it's for attacking the credibility of a witness. You introduce felonies or certain convictions that fall within the time frame in order to impeach the credibility of that witness. There is no Nevada law that I am aware of or that plaintiff has referred to that would preclude us from saying, well, Zaon has been through the criminal system. They already brought up the convictions, so the jury is already aware that he was convicted of these two crimes, and would not preclude Zaon from having personal knowledge of his path through the system, the grand jury indictment. And I will say for the record, he was actually charged, even though the grand jury didn't return an indictment, he was still charged with this crime. And then the DA eventually decided not to pursue it and stated that on the record at Zaon's sentencing. So this is important in this particular case because they are trying to get punitive damages against Zaon Collins on the basis that he was driving under the influence. And they have to show by clear and convincing evidence that that was the case. It is highly relevant to that inquiry and for the jury to hear that it was not pursued criminally and the grand jury failed to indict and the DA eventually dropped the charge because the evidence of a DUI was not there. So,
Okay, hold on a second.
yeah,
Are you going after punitives on just the DUI aspect, or is it also the reckless driving because of the level of speeding? Am I missing something?
Judge, the
I thought
punitives
it
are
was one.
based on the statute, which states that as if the defendant is over a certain threshold with respect to the
Yeah.
nanograms per milliliter, then we are entitled to punitive damages because it shows that they are impaired per se. And this was
Okay.
extensively briefed before Your Honor in the pretrial phase.
But there's no claim here about the reckless driving.
Well, I do
Related to
think,
punitive,
I do
because of
think-
the extent of the speeding.
I do think this extent of speeding also gives grounds, separate grounds for punitives, Your Honor.
Okay, has that been alleged somewhere, or has it
No, it
not
has
been
not.
alleged?
Well, punitive damages was alleged in the
Okay, I'll take a look at your
in the
complaint.
plea,
Okay,
but I didn't say it was specifically for the speeding. I will admit that.
okay. Okay, sorry, Ms. Zena, keep going.
yes, Your Honor. So in my opening, I would like to state they are going to be calling Dr. Kelly as the toxicologist. He was the same toxicologist that testified at the grand jury hearing. He gave testimony under oath that I will be able to cross-examine him on. And then as a result of Dr. Kelly's testimony at that stage, the grand jury failed to return an indictment, of which Zaon Collins has personal knowledge and can testify to. All of that is admissible evidence.
Okay. Okay, I'll let you say that.
Okay, thank you. Your Honor.
I don't think you should say did not find it viable, though. I think it just say the grand jury did not indict Zaon with a charge for driving under the influence.
Thank you. I will amend my slide right.
One more quick item on
Or
the-
maybe even just it did not indict Zion for driving under the influence, because the charge was brought, correct? Okay, so is the correct statement here, the grand jury did not indict Zion for driving under the influence? Is that correct, or am I missing something? Okay, so find it viable and with a charge should both be removed, because he was charged, I
So,
believe, if
My
I'm
slide
correct.
now says Dr. Kelly gave testimony in front of a grand jury. The toxicology report did not provide a basis for the DUI charge. The grand jury did not indict Zion on that charge.
Okay, so it doesn't say filed a flawed report?
No, I
That's
said
not-
based on the previous objections.
Sorry, can you read it again one more time, Stephanie?
Yeah, for me too, please.
Okay, Dr. Kelly gave testimony in front of a grand jury. The toxicology report did not provide a basis for a DUI charge. The grand jury did not indict Zaon on that charge.
And you have a good faith belief that all that is supported. But, well, the first two things, obviously, he gave testimony. He gave testimony, his testimony said that he didn't believe the report supported a DUI charge.
So, no, Dr. Kelly testified as to supporting the DUI charge, but the grand jury did not believe him.
Okay, read me the slide one more time.
Your Honor, we would just maintain our objection, especially based on the difference in legal standards. What the grand jury is deciding to do is based on obviously a much higher standard than what we are asked to prove here.
You're gonna get to say that.
Okay, so the slide says Dr. Kelly gave testimony in front of a grand jury,
Okay,
and then I can say, and I think that is confusing. You're right, Your Honor. I can say the grand jury did not find that the toxicology report provided a basis for the DUI charge, and the grand jury did not indict Zaon on that charge.
Oh, can I
did
take
the
one?
grand jury actually say the thing about the report?
Well, they didn't return an indictment, so I think.
Can
it's
we
a
just
fair
say that?
assumption, But I can take that back. Dr. Kelly gave testimony in front of a grand jury. The grand jury did not indict Zaon on that charge.
Okay,
In the DUI charge.
Obviously, we
so
don't,
your slide's gonna say Dr. Kelly gave testimony in front of a grand jury. Next part, the grand jury did not indict Zaon for driving under the influence.
Correct.
Okay, and what about the stuff in the box? Is
You
that
do not
coming
have
up
to
too?
accept junk science. Is there any objection to that?
yes, that's argument, yeah. That's not the evidence will show. It says you don't have to accept junk science. It's argument. What's the evidence gonna show?
You took off the false, the big stamped false, right?
Correct. Yes, I did.
and the credibility titles.
Yeah, this shouldn't say you do not have to accept junk science.
Okay.
Okay,
Last item, Judge, going back to slide 8. The
going back to 8, got it.
first bullet point, and then which states paying his debt to society, and then the entirety of what's written in the box there. Zaon will carry the weight of the actions he made on that day for the rest of his life. Judge, Zaon paying his debt to society is irrelevant here in the civil action. It's prejudicial. I mean, what bearing does this nebulous term here have on the issues, the tribal issues in this case? And similarly, Zaon will carry the weight of the actions he made on that day for the rest of his life. It's essentially shifting who the victim is here. It's indicating that he has sustained damages. It's almost adding to our burden of proof that we have to show that these damages alone
Okay.
that he sustained.
Response.
Yeah, thank
I
you.
got it.
Thank you, Judge.
If the argument is that I cannot reference the fact that Zaon Collins was criminally convicted and has been sentenced and is paying his debt to society, then why did the convictions come in the first place? They brought up the convictions. Paying his debt to society is one of the most common ways to say what criminal defendants do after they've been convicted. They are placed into jail, into prison, on probation, and that is considered paying their debt to society.
No, but here's the problem. This case is about whether he owes reimbursement. I'm sorry to say it so crassly, but that's true, whether he owes reimbursement to any of the plaintiffs.
Right.
That's not done through a jail sentence or
It is
anything of the
not done,
like.
and I don't intend to say that this is just all he needed to do. It is just a fact. He was criminally convicted. He was sentenced. He served his time in jail, and he is currently serving on probation. That is what he is currently doing.
Your Honor, I have a little bit of input as well.
Okay, go ahead.
Is in their opening and throughout this basically is saying that he needs to be held accountable as if he just walked on this deal. He's not here. This is nothing. This is frivolous to him. We got a life that's lost, etc.
But
They're
this
bringing up
isn't
the
a response to their opening. This is your opening. It
right.
is not supposed to be argumentative.
So the point being, and I'm sorry, Brett, the point being though, is that we are showing that Zaon is being held accountable at every step of this way. I have zero intention.
And you
of-
can write here, evidence will show that Zaon has been held accountable if you want, but not paying his debt to society. Evidence will show that Zaon has been held accountable or is being held accountable, whatever you want to write there, but not paying his debt to society.
So are you saying that I can't say that either then? In just without it being on a slide
That you can't say paying his debt to society.
or serving a debt to society?
Evidence will show Zaon is serving his debt to society or has.
I'll make it clear, that's not serving his debt to the Echevarria family. He is serving his debt to society because that is how the criminal justice system works. We brought in the convictions. He has been convicted and he is serving that time. And
Yeah, but here's where they get to use the convictions. They get to use the convictions because technically then they've already met some of their burden on some parts of this. The convictions are not being used and shouldn't be used to discuss that there's already been some kind of compensation to the plaintiffs via any kind of, unless there has been. I mean, was there restitution?
yes, there was restitution ordered.
Okay, how are we addressing that?
I was not gonna bring that up in opening.
Okay.
What was the
Okay.
restitution?
I believe it was $1,000.
Judge, if the defense has to distinguish between Zaon paying his debt to society from Zaon paying his debt to the Echevarria family, then how is the former relevant? When we're telling the jury that he has or is paying his debt to society, well, in a criminal context, perhaps, but again, how is that relevant? But certainly not in a civil context.
Okay, so you have a problem with the first bullet point of this slide. What else do you have issue with in this slide, if anything?
Well, saying he has been, okay.
I just want to know where your objections are so I can make rulings and
My
we can
next
move on, and then
objection
we'll
is
make a
the-
better, record after
Page,
we dismiss the jury for the day.
page 10.
Oh, wait, hold on. So there's nothing else on this page that you're objecting to?
No, the
than
other thing in this page, or we're on page 8, I'm sorry.
Yeah, page 8.
It's the Zaon will carry the weight of the actions he made on the day for the rest of his life. as
Yeah,
if-
that's argument. That's out. That's out. We can make a record of it later.
Okay,
So that's out.
Settle on the first
And paying his debt to society is out. You can say that evidence will show he wasn't convicted of a DUI. Evidence will show toxicology report did not support a DUI charge. What else do you plan on saying here associated with this slide?
Associated with this slide, was,
And then I'll let you make more of a record later. You're not making your complete record now, but I just want to make a ruling and get them in because we told them that we'd get them in.
sure. So, he was, and this is paraphrasing, convicted of, the charges as you've heard. He
Okay.
is serving a debt to society.
I don't understand the serving, Your Honor. He served 58 days in jail. I don't know why he would still be serving.
He's on probation. That's still, that counts.
I think she needs to make that clear because she's making it sound like he's been in jail for all this time or something. I don't understand.
How is that relevant to our?
Well, I think they know he's not in jail right now. I mean, I think we've made that pretty clear.
I mean, if she wants to tell them that he served 58 days in jail and then now he's on probation, it's important that it's specific. Otherwise, I think it's, she's misstating things and she's
Well, you
leading.
get to make that argument in closing that she misstated stuff in opening if you want. Okay, so you want to say evidence will show he's serving his debt?
He is serving a debt to society as a result of his criminal convictions. And we're not here to determine any.
And
further-
your problem is you want that to be specific. No, that's not required at this stage.
We
but
also
evidence
think
will
it
show
shouldn't
he
come
is
in at
serving
all.
a debt to society.
I'm sorry, we also think it shouldn't come in at all. Serving his debt to society is completely irrelevant to what he has to pay in this case, and it confuses the issues. It's prejudicial. It's confusing to the jury. Whether he's serving a debt to society is completely separate and distinct from what he has to pay in a civil case for damages, for compensatory damages, Your Honor.
And I just want to state for the record, at no point during this opening argument or opening statement do I intend to state that just because Zaon was criminally convicted and served time and is on probation, that somehow he should be absolved from financially compensating the Echevarrias. That was not my intent. This is not an interchangeable.
I'll let you say evidence will show he's serving a debt to society. I'll let you say not convicted of a DUI. I'll let you say toxicology report did not support a DUI charge. The stuff in the box on this slide comes out. The first bullet point comes out.
Judge, is it not, he's serving a debt to society as a result of his criminal convictions? I thought that's what was originally settled on.
That's fine, as a result of his criminal conviction.
No, you want me to move quickly, Your Honor, so the next thing.
No, it's fine. What's the next one?
Page 10.
Okay, what's the issue with page 10? Which bullet points or what's the problem?
Well, first, the thing in at the bottom, Zaon has been haunted by the consequences of actions ever since. This is the same as what it was before.
That's out. The box is out. You can make a record of it later.
Thank you.
Yep.
The other thing was, would not intentionally jeopardize his commitment to basketball. I don't understand that. No one's argued that he intentionally caused a crash here.
Okay.
I think it's confusing.
Well,
To
I
the
mean,
jury.
I also talk.
Are you agreeing for that to be out?
No, I also explain what I mean. I don't put my verbatim, just like Mr. Ladah doesn't, I don't put my verbatim argument up on.
Is there an argument he intentionally?
No, Mr. Ladah went into great detail about how Zaon, he claims that Zaon smoked weed and then Zaon lied about it and showed video clips and all of this, and his credibility is in question. And Zaon maintains he does not ingest marijuana. And the reason, one of his reasons for that is because he does not want to jeopardize his commitment to basketball. So if Mr. Ladah was able to go on for 10 minutes about Zaon not being credible because he was interviewed by police officers after a horrific crash and and he thinks that Zaon is lying. The defense gets to say, well, you're going to hear from Zaon. He does not smoke marijuana. He does not ingest marijuana. And the reason he does not ingest marijuana, which they will hear from Zaon, is because he does not want to jeopardize his commitment to basketball.
Okay, so is the statement would not intentionally jeopardize his commitment to basketball by ingesting marijuana?
Yeah, so yes, I just
Okay.
don't like to keep my slides very wordy.
Why don't we just add by ingesting marijuana on the end of that?
So,
Okay.
I mean, and the last thing, Your Honor, is the good kid. I mean, the truth is, it doesn't matter if he's a good kid or a bad kid for compensatory damages. I don't know why that's relevant.
Yeah, I would agree. That's out. Good kid who made bad decision. Yeah. Okay, you can argue why that should have come in. We'll do that after your opening. Okay, anything else?
Can I take out the word good and just say he's a kid who made a bad decision?
I mean, here's the problem. He's not a kid, right?
He was a kid at the time.
Well, he was
He
under
is 19
18.
years old.
I mean, I'm a little worried too that we're calling somebody who was over 18. No, take it out.
Judge, there's one more reference to kid. I don't have it in front of me, maybe counsel can help. It says something like, seeking whatever $1 million from a 23-year-old kid. Of course, indulgence, I'll find it. It's towards the end, I believe.
Okay, so the next issue is what? Page 13. Well,
Yeah.
Okay.
Can we change that to a 23-year-old college student?
I don't know why it's relevant whether he's in college or not for compensatory damages.
Yeah, page 13.
What is the relevance of his position when we're talking about compensatory damages? His I don't want to call status, but I guess that's like the easiest way to
We're
define
allowed
it.
to personalize and humanize Zaon Collins in this matter. That plaintiffs got to go on and on about how they met, how she met her husband, how he became a part of their lives. I also get to humanize the defendant. He's not.
No, but this is a little bit different. They're claiming that she lost that relationship. That's why they get to go on detail about that.
Right.
They're claiming there's a loss of relationship, but like your client isn't making a claim against them for a loss of some personal relationship. So I don't know why his personal stuff factors in here. It's not
So I can't say, so if I can't say anything about the person who Zaon is, that does not allow me to essentially humanize him to this jury. He just becomes this kid on a screen who unfortunately contributed to a major accident.
Yeah, but
So-
how does humanizing him? I understand why you would want to do it, but the problem is, and maybe I'm misunderstanding your goal here, but the case isn't, he's not claiming some form of damage where, I mean, I did not get the feeling they were trying to humanize their clients. I got the feeling they're trying to discuss what their clients lost. Like evidence is going to show there was a super loving relationship that's now gone from their lives. And the issue is your client being college student, your client being 23, your client being whatever your client is, does not change or does not affect her losing her husband.
Right, but I mean, it's not even about that. It's just who he is. He's a 23-year-old.
Okay, but why is that
person.
relevant when we're talking about, I mean, does it matter if it was a 70-year-old or a 50-year-old or a 20-year-old that hurt somebody in an accident? How does that matter when we're talking about what were the damages? Like the damages are the damages from your perspective. Like you're going to get to ask him who he is a little bit on the stand, but if you want to use it to humanize him, no, then what you're doing is you're trying to elicit sympathy from the jury. And don't we have an instruction that says exactly that we can't do that?
Well, I mean, I disagree that I can't at least give a background on who this kid is.
That's not what I'm saying. I'm not saying you
So-
can't give a background, but when you present it like this, and you're telling me you're doing it to humanize him.
Well, not
No,
just that isolated statement. It's taken as a whole. I need to present a picture of Zaon because they've had issues with every single personal detail I put in here. So his commitment to basketball, how old he is, what he's doing.
well, you're not putting the commitment to basketball in to try to say, oh, don't give them all their damages because yeah, my client deserves to be able to have a basketball career. You're putting the commitment to basketball in, at least as I understand it, because you're using the commitment to basketball to say, no, my client wouldn't use marijuana because of his commitment to sports and how that would jeopardize that. Am I not understanding? Or are you putting the commitment to basketball in to humanize him? Because if that's what's happening, I need to go back on the ruling.
And I think maybe I'm just not coming across very clearly as I'm trying to make changes and listen and argue, and I apologize because we are running out of time.
Yeah,
So during opening statement, right, just as plaintiffs are, I am allowed to place who Zaon is in front of the jury. And why certain aspects of his life.
for certain purposes, I agree. Yes, you are allowed to do that for certain
Right.
purposes.
And so if the issue is just surrounding the use of kid or his age, I can amend that and I can make that, let me see that slide. Okay, how about I just sort of.
The problem I have with this slide, Your Honor, obviously, is that it places his age and he's in college in the context of the verdict, saying, oh, look, you can't give $35 million to someone this young. You can't give $35 million against someone who's in college. It's the exact same thing we were concerned about in voir dire when we're talking about sympathy.
It doesn't go to their damages. Okay, so
So I already, and you know, I'm not trying to be argumentative. or
no,
critical.
it's
I already
fine.
said
You
everything
you
it
have
out.
you get to argue your side. Go
so-
for it.
And I was not directing that at you, Judge. I apologize. So if I say the plaintiff is seeking on an unreasonable amount to just take out from a 23-year-old entirely.
From a 23-year-old kid, as I'm hearing it, and as I'm hearing what the proposed statements are going to be at opening, should be off this slide. The
Okay,
two wrongs
good.
don't make a right should be off this slide. Okay, next slide. Or what are the other objections? And look, I know we're just talking about the slides here. We're doing our best to also talk about potential argument, and I'm not angry. I'm just trying to move quickly.
Same here, Your Honor, and I hope it's not taken that way from you, and I hope it's not
Not
taken
at
that way
all.
from me.
We are just talking about the slides. We're where we can, we're also talking a little bit about argument, but if someone feels like there's a violation of the rulings I'm making right now because there's certain argument offered, you gotta object to, okay? I'm not saying violate it, but object if you think it goes farther than what I'm saying I'm permitting and ruling. But yeah, there shouldn't be argument in opening statement.
I agree with that, Your Honor.
I'm concerned about slide number 17, Your Honor, to try to go
Okay.
quickly. I'm sorry.
Let's do it. That's the next issue?
Yeah.
Okay.
Where it says what this trial is not. Criminal trial, I agree, it's not a criminal trial. Moral judgment, that concerns me. I don't,
Then what this trial is not, we're getting into argument here. So
I think this whole slide is verbal, is argument, Your Honor.
go ahead, Miss Zena. And like I said, you'll get to flush this out more. Just do the best you can to give me an idea of your response at this time. So I make sure I'm not just taking my own thoughts on what would be a response to this and replacing what yours actually are.
Sure. So this slide just talks about, hey, we are here to ask you to fairly assess the facts, fairly assess the damages, and stay reasonable. We are not here, this is not a criminal trial. We are not here to cast moral judgments on anybody because that is not the rule. They will be instructed on the law. It is not a moral judgment that is implicated here. And that is literally all I was saying about that slide. I wasn't gonna go really into that one. I wasn't really gonna go into depth on.
Okay, and Mr. Ladah, you have a problem with the criminal trial part, the moral judgment, or the emotional fueled, or all of it?
Moral judgment is an issue, Your Honor. I don't know any instructions that say, they're not to use moral judgment.
Yeah, take off the moral judgment. I'm not sure about the reason why, but let's flush that out a little more after you do the argument. But yes, I think moral judgment should come off of that slide. So you don't have, there's no objection to the criminal trial part, right?
No objection.
Okay, and is your objection also to the emotionally fueled or no?
Well, yes, I have objection to emotionally fueled. I don't think that's exactly what the jury instructions say at the end, the standard jury instructions on what they're not to consider. They're supposed to make their damages in calm and just, I think is what it says. I could pull up the instructions.
Okay, what is your response to that generally, Ms. Zena, if he's saying that emotionally fueled doesn't properly, I mean, they're gonna get instructions on the law later.
Right, they're gonna get instructions that specifically state you are not to use emotions. And this is just, I'm not quoting the actual instruction that we will use, but the sentiment is the same. You're not, I'm asking the jury to do their best to not, in an emotionally fueled trial, to be able to set those emotions aside and be fair and objective. That's a standard statement to a jury in an opening.
My response quickly, Your Honor. I mean,
Go ahead.
I'm not aware of a standard jury instruction on damages that says they can't use emotion. The only instruction I'm aware of says that they're not to let sympathy impact their judgment. But there's nothing that says they can't use emotion.
I mean, during voir dire, we went over whether or not somebody could set aside their emotions 100 times.
That doesn't mean the jury instructions say that, though. I'm not aware, if they can show me a jury instruction, standard jury instruction on damages, that says you can't use
But my
emotion.
opening doesn't need to track the language of a jury instruction, right? Because the jury instructions will be given. The sentiment is, and the sentiment that was expressed during voir dire is, you need to be able to set aside your emotions, jury. Can you set aside your emotions and listen to the objective evidence in this case? So that is the tenor and the statement that I'm trying to get across to the jury that that plaintiff's counsel himself enunciated dozens of times yesterday.
But if it contradicts the jury instructions, Your Honor, it's jury nullification.
Okay,
Well, then-
I'm actually a little worried about a lot of, I mean, a lot of this slide is argumentative. Okay, what's on trial? You can say that, fine, I guess. It doesn't sound like there's gonna be an objection to that. What this trial is, fairly assessing facts, fair damages, staying reasonable. The other box is out. It's argumentative. The other box is out. Okay,
The last one would be 18, Your
So-
Honor.
Your Honor, on the other box though,
you can
he-
say it's not a criminal trial. I'll let
Okay.
you say that.
thank you.
Okay, what this trial is not. It's not a criminal trial. I think that's all correct. Moral judgment, emotionally fueled, they're gonna get instructions on what they're supposed to do. And you can say you'll get instructions later on from the judge on what you're supposed to do if you want, but that's all that should say there. Look, we have to be real careful with argument, and look, closing stuff's gonna be different, and I think what we will do is we will have a pretty lengthy meeting before closing, and I'm gonna ask for your slides before closing. With more time before than just a few minutes before we do the arguments. Okay, any other
The last one
objections
is
to
18, Your Honor, just to try to move quickly. I'm fine with the remain reasonable box. I have a problem with the second sentence. It is your duty not to not become swayed by emotion and the need for retribution. I mean, the judge.
You're giving them an instruction there. They'll get instructions on the law later. That's out. Okay,
Can I keep remain reasonable, evaluate, can I just take that first sentence? out?
evaluate the full picture and award the amount that is reasonable under the circumstances. I'm gonna ask you to. Is that what you're gonna preface that with?
Yes.
Yeah, that's fine. I'm gonna ask you to evaluate the full picture and award the amount award an amount, probably not the amount, but you can say either one. That is reasonable under the circumstances. Yes, take the middle sentence out, or that middle phrase, I guess. It's not a full sentence. Okay, anything else?
Let me just look through real quick. I think we hit everything. And the last one would be page 4. The word malice in there. No one's alleged that this is malicious. There was an intent to harm is what I'm assuming she means by malice.
Okay, so your objection is, how is this objectionable in opening? What's the basis?
Yeah, because she's contrasting with an accident, so I have no problem saying this case is about an accident. But
Okay, so she's contrasting it with the accident, so what is it?
it's prejudicial, it's confusing the jury.
Why would it not be allowed in opening?
Because it insinuates that we're alleging malice. There's no argument that this is malicious.
So it's argumentative.
I would say argumentative and prejudicial.
Okay,
And
this case is about an accident. Take out the not malice, period.
They are alleging punitive damages.
Okay,
and-
but you can get to that later, but this is argumentative as it's phrased. This case is about an accident.
the punitives is in the second phase, Your Honor, is our position, not here. So it's important to keep everything
If
separate.
something comes up at trial that warrants the not malice, fine, but that's argumentative to put it into this phase. What's the next part?
I think that's it, Your Honor.
Okay. Okay. Anything else? Are we ready for them to come in?
I don't want
And I'll let
to,
everybody make more record later.
I don't want to annoy anyone. I think we need to object contemporaneously, Your Honor. So if you can just deny my objection, that's what you're planning on doing. Yeah,
Okay.
they took out, had no intention of harming.
Which
anyone.
part are you objecting to now?
Oh, he has never stopped feeling remorse. I'm assuming that's out, right?
We didn't address that.
Oh, okay. Page 3, he has never stopped feeling remorse. I don't know why that's,
What's the objection?
the objection is, it's irrelevant whether or not he feels remorse for the compensatory damages phase.
Response?
I disagree that it is irrelevant to the case. The defendant, intends to take at least partial responsibility for this accident. It's relevant that he is remorseful. He has apologized to the family a number of times. It's just, it's a state, it's not argument, it's a fact. It's just, he's sorry.
Evidence is gonna show that he's never stopped feeling remorse. Okay, I understand the objection, but on that basis, it's denied. You can leave it in. Okay, anything else?
Are we saying taking out, he had no intention to harm anyone behind the wheel?
Oh, I didn't hear an objection for that one. Had no intention to harm anyone behind the wheel.
That would go to just as. the
Evidence is
standard
gonna
rate
show he had no intention to harm anyone behind the wheel. That's what you're gonna say.
Correct.
No one's alleged he had intention to harm anyone behind the wheel, so it's confusing and confuses the jury on what we're alleging and what they're looking for.
Yeah, but you're gonna allege that he was going at 80 what miles per hour and driving while under the influence, right?
Correct, but that's different than intending to harm someone, Your Honor.
But you're bringing punitives on that basis, right? The high level speed and and driving while under the influence.
Correct.
Okay, so I'm gonna let him say that.
So
And just for the record, are we good with the photograph that I used to examine and the way I cropped it with where there's an issue?
I mean, our position is the same. We don't think a photo should be
Right.
showed of him because that should have been disclosed
I
throughout the
hear you,
case.
but based upon the court's ruling, I just want to make sure that the court doesn't have an issue with how we presented that photograph. And
I think your photo comports with my ruling,
Thank you.
but I understand your objection to it. However, let me ask you, did you not know he looked like this?
No, I knew he looked like that.
Okay, and the photo is consistent with what you believe he looks like today, right? Or at the time of the accident? Or similar to what he looked like? Like, I'm not talking about if his hair is an inch or two longer, but it's the same person, right? There's no doubt this is the person, right?
Yes.
Okay, then it's fine.
Thank you.
Okay, anything else?
Oh, yeah.
Nothing
gonna
for
bring him in.
Chair.
We're gonna approach after you're done, Miss Zena, if it's past 4:30, and I'm gonna find out from you how long you think you're gonna be. But if you're really only gonna be like quick 5 minutes, you can just do this to me. Actually, don't do it that because that's like a little bit rude. But just say I could finish in less than 15, okay? And then we get up and do it. But otherwise, if you know are you gonna be more than 15 minutes, or do you want to see what she says before you tell me?
Should be more than 15 minutes, yeah.
Okay.
And I won't be an hour.
Okay, then we're good to go. Let me tell him to bring him in. We're good. Let's bring him in. Thank you. Everyone can please be seated. Do council acknowledge the presence of the jury?
Yes, Your Honor.
Is defense counsel prepared to do opening statements?
Yes, Your Honor, I
Okay,
apologize.
you need a second?
No, I'm. Thank you. I apologize, Your Honor. It's just fixing the slide.
Fine. Do you need, oh, it's right there. Okay.
May I proceed, Your Honor?
I'm sorry?
May I proceed?
Oh, yes, please.
Good afternoon, everybody. Oh, I don't.
Oh, yeah. I'm sorry. Here you go.
Already.
And you just have to press it and it turns green and it'll be on.
Is that good? It's green. Is that good? Yes. You're welcome. All right. Good afternoon, ladies and gentlemen. As you know, my name is Stephanie Zinna. I represent defendant Zaon Collins with respect to the lawsuits filed by the Echevarria family. Now, I want to tell you that you're aware this case involves an undeniable tragedy. We know that. This case is about a heartbreaking accident that changed the lives of two families forever. And there's nothing that can be done to replace Eric Echevarria in their lives. Now, a life was lost, a family is grieving, a man has died, and Zaon Collins will carry the weight of that for the rest of us.
Objection, Your Honor, for the
This-
reasons stated outside the presence.
To the statement that am I assuming that the objection is to what? The immediate last statement, right?
Correct, Your Honor.
State.
Is that okay? Can you hear me? Okay, okay, thank you. All right, ladies and gentlemen, this is a case of a terrible accident. One that unfolded in a matter of seconds, in a real world scenario filled with split-second decisions. At the time of this accident, Zaon Collins was a 19-year-old senior in high school who was driving too fast. He made a mistake. He was driving too fast. That is not something we will hide from. That is not something we will excuse. He was driving too fast. But this trial is not just about how fast he was going. I want to give you the full picture of everything that happened leading up to this crash. Zaon Collins was driving to basketball practice for the day. He left his mother's house around 3 o'clock in the afternoon, heading to his usual spot to go practice his passion. He was driving up a road, a straightaway road, clear visibility, and yes, he was driving too fast. There's no stoplights, there's no stop signs, and he made a poor judgment. As Zaon went up the road, Eric pulled in front of him to make a left turn. And it happened suddenly, and Zaon was unable to avoid the collision. We're going to show you what the ring camera from a nearby house showed about that accident. I believe you saw that in plaintiff's opening as well. We've zoomed in on this. Now, unfortunately, this was not something that Zaon was expecting Eric to do. He was not expecting Eric to try to make that left in front of him. He thought he saw him, and you will hear the events leading up to why Zaon thought he saw him from Zaon himself. Accidents, even terrible ones, are just sometimes that. You will also hear that and have heard that Zaon was criminally charged and convicted as a result of this accident. That's true, he was. You will also hear that he was not convicted of a DUI. You will hear evidence that shows that the grand jury actually failed to indict Zaon.
Objection for the reasons outside the presence, Your Honor.
Overruled.
You'll hear evidence that the grand jury failed to indict Zaon for that charge. Despite this, the plaintiff will still attempt to show that Zaon was impaired. They will rely upon Dr. Kelly, who gave testimony in front of that grand jury, who failed to indict Zaon. And you will see that he has nothing but speculation and guesses. It did not support the criminal charge, and it does not support civil liability in this case.
Objection, argument, Your Honor.
Sustained.
Zaon made a bad decision. His passion is basketball, and he takes that commitment very seriously. You'll hear from Zaon that he does not use marijuana recreationally, he does not drink, he does not smoke, he does not ingest, he does not use drugs. And he does not do that because he takes his commitment very seriously. He is in college, he plays basketball, that is his life. Plaintiff is going to try to do everything they can, as you saw, to paint Zaon as a inconsistent witness. And we believe that the evidence will show that that is actually not the case. So many of the instances that you were shown, you will see the full story behind some of those instances during this trial and what the evidence will actually show. I want you to remember, ladies and gentlemen, that this was a brief lapse in judgment for Zaon. This was not intentional. This involved human error. Zaon made a poor decision, and Eric made a human error by turning left in front of a car when the path was clear behind him. The law requires you not only to consider what my client did wrong in this case, but
Objection, Your Honor. That's the law.
Sustained.
you are to consider not only what Zaon did wrong in this case, but you are also to consider what Eric did wrong.
Objection, Your Honor. What they are to consider.
Sustained.
Speed was a factor in this accident. And we understand that, and that is true. Speed was a factor. But it is also not it is a rule of the road, you don't make a left turn in front of a car. When you don't yield the right of way, you have also contributed to an accident. Eric failed to yield the right of way despite the path behind Zaon being clear. Unfortunately, Eric made that choice as well. Zaon made poor choices to speed. Eric made poor choices to turn left and failed to yield to an oncoming vehicle that he clearly saw. We hope that you could hear this evidence. We hope that you can remain with us and be objective and reasonable and not use this opportunity to let your emotions guide you to the point where you cannot set aside your sympathy for the defendant, for the plaintiff. Right. So we hope that we want to use this opportunity for Zaon to tell his story as well. We want to have him apologize yet again to the family. He has apologized to the family before. He wants to do that again and is looking very forward to that opportunity to do so again. He wants to atone for his choices. And he wants to.
I object, Your Honor. This is irrelevant.
Overruled.
Zaon wants to atone for his choices in this. And you will hear that testimony. Plaintiff stated in his opening that Zaon has refused to accept responsibility for this accident to this day, and that's simply incorrect. As you heard, Zaon has pled guilty to 2 criminal convictions and admitted guilt. By pleading guilty to a crime, you admit guilt. He's taken responsibility and he is here to take the responsibility in this proceeding. While we cannot undo the pain of that day for the Echevarria family, we trust that you will be able to weigh the facts carefully and return a verdict that reflects the law, not just sympathy. There are going to be calculable damages in this case that you will hear about, and those are damages that in civil cases, we are able to put numbers. You will hear from plaintiff as to what they present those damages to be, and you will hear from our economist as to his thoughts on those damages, and he'll provide that opinion as to what his opinions are as to some of those categories of damages. In addition to those calculable amount of damages, plaintiff is going to be asking for an unreasonable amount of. They are banking on your sympathy in a.
Objection, Your Honor, or this is argument.
Sustained.
You will hear.
Strike, Your Honor.
The last statement about banking on your sympathy, is that what you're asking to
Yes,
strike?
Your Honor.
Yeah, that will be struck from the record. Please disregard the statement. You want to repeat exactly what you want me to disregard, and I'll make sure that we're talking about exactly the same thing.
They will be banking on your sympathy.
I'm going to ask you to please strike you'll be banking on a sympathy comment. And not consider it in your, when you're looking at this case as a whole. Go ahead, Ms. Zinna.
You all are hearing to go hear painful testimony. You're going to see painful pictures. You're going to see painful videos. You've already seen some of them. You're going to see painful, difficult evidence in this case. Now, unfortunately, we have two drivers who made respective mistakes. Each driver made a mistake, and at the end of this file, you will see that there are two drivers who made human errors. Because that's what they are, they're human errors. There's no doubt that Zaon made a mistake. But we want you to evaluate this case from an objective point of view. We want you to listen to the evidence, not only going into the factors and the actual facts of the accident itself, but also when it comes to the damages. We want you to stay objective and reasonable as plaintiffs ask for damages in this matter. While we understand that they have lost a loved one, we don't have a mechanism to replace somebody. That's why we're here. We don't have a good mechanism to do it. We ask you, ladies and gentlemen, to help us do that. And we can only place a fair amount on a person's life and award those damages. That is what the law, that is what is required in this trial. It is damages to a help to attempt to help the family with their loss. It is not a replacement for Eric. It is not intended to be a replacement for Eric. There's no way we could do that. That's impossible to do. So ladies and gentlemen, we're not asking you to attempt to replace Eric. We are going to be asking you to evaluate the compensation in this case to help the family be able to move on. Help bring them closure and help them put this behind them and move on. This trial is about reasonableness throughout the court. I want you to remember that word as you go through reasonableness. All people ask it's reasonableness. We want you to look at the facts before reaching your decision. We want you to evaluate what is presented to you, and we want you to apply your best ability in assessing reasonable damages and fault in this matter. Now, I want to be clear, we are not asking that you do not award damages in this case. As I stated, we do believe that Zaon bears responsibility for his part in this accident. And he has taken that responsibility. He has pled guilty to the crimes. And he is here to atone for that and face you all and accept what the next phase is for his life. And he is not going to say, we're not going to say that dollar amount is. there is an amount of compensation. And once you hear all the evidence, I hope that you will consider that in the light of reasonableness. Thank you.
Okay. Does anyone need a break at this time? Okay, seeing no one, Mr. Johnson, are you prepared to do your opening statement?
Yes, I am, Your Honor.
Okay, go ahead.
Your Honor, for the record, we have not seen Mr. Johnson's PowerPoint.
Nor will you. Mr. Johnson, go ahead.
Do you want the mic?
I think so. Much obliged. Ladies and gentlemen, my name is Brad Johnson. Met before, my partner is Tyler Watson, and this is our client, Marvin Collins. We're here on this deeply emotional case. Let me begin by acknowledging the undeniable tragedy at the heart of this case. A life was lost, and nothing can diminish the sorrow of that fact. But this, as it relates to my client, Mr. Collins, is not a case about sympathy. It's about responsibility, truth, and justice. That's what we're all here for. The plaintiff have accused my client, Mr. Collins, of being responsible for that death of Mr. Echevarria, an accusation that we believe the facts will show is not only unsupported, but is also fundamentally wrong. They're also going to be asking, I believe, the evidence will show and the arguments will be made that the damages go far beyond what is reasonably fair or supported by the evidence. What do we intend to show is that Mr. Collins did not cause the death. We will demonstrate through the evidence that what happened was a terrible accident and not a product of recklessness, negligence, or wrongdoing on behalf of my client, Mr. Collins, Zaon's father. Plaintiffs have alleged, in part, that my client negligently entrusted his vehicle to Zaon, called it a muscle car. Listen to that carefully, because you'll hear testimony about Mr. Collins, a 60-year-old man's muscle car. But the facts will show that Mr. Collins allowed his son on very limited occasions to use his vehicle, the Charger. And on this particular occasion, he drove his car over to Zaon's mother's house so that Zaon could use it for the very limited purpose of going to basketball practice at 3 o'clock on the afternoon of December 30th on a bright sunny day. That's what we believe the evidence will show. Mr. Collins was not there. He wasn't riding in the car. He wasn't supervising the car. His son was 19 years old. As I stated, he gave the car for the limited purpose. Mr. Collins did not live with Zaon. Zaon lived with his mother. Zaon drove other vehicles. Besides that, that was owned by his father. But simply because he didn't live with the son didn't mean he didn't love his son, proud of his son, or he would naturally help his son when he needed it. So those are the facts that will come out on how Zaon was in Mr. Collins's vehicle on that day. They will claim that Mr. Collins should not have allowed his son to drive his vehicle because he had previous speeding tickets, and they put them up on the board. And he went through them pretty fast. We believe that the evidence will establish that Mr. Collins was unaware of those speeding tickets, which involved operations of vehicles Mr. Collins didn't own. Those tickets were flashed up and down. Those were vehicles he did not own related to speeding. Furthermore, those speeding tickets were issued over 2 years before this accident. There will be no evidence presented, in my opinion, that Mr. Collins is aware of anything to suggest that his son would not do what he said he was going to do by being able to use his car. What I mean by that is he used his car for the intended purpose. Get up, drive to basketball practice, and presumably get there safely. And that's exactly what he did when this accident happened. He was going to basketball practice. Now, Mr. Collins has a right to a complete defense. He has a right to defend the claims against him. He has the right to challenge that his son was responsible for the accident. That is his right. That is his defense. We'll present evidence that although Zaon was clearly driving in excess of speed at the time of the accident, that video that was presented, you're going to want to watch it over and over because that lays it all out. You heard attorney arguments. You want to see the facts, you have to watch the video. It was a straightaway. There was plenty of visibility. His car was easily visible. You'll make that decision, but that's what I think the evidence is going to show. Mr. Echevarria had to yield to oncoming traffic, whether they're driving at the speed limit or not. It wasn't a protected turn, and it's undisputed. That might be an accepted exhibit now, but it'll be undisputed that Mr. Echevarria did not yield the right of way clearly.
Objection, Your Honor.
What's the basis?
The evidence will show.
It's opening. If you're saying the evidence will show, it's fine. Overruled.
Thank you, Your Honor. Evidence will show he did not yield the right of way. It's there in black and white. It will also intend to show that Mr. Echevarria also had a significant shoulder surgery approximately 2 months before that accident. He was driving.
Objection, relevance, Your Honor. There's nothing on this. I don't know what this is. And may we approach?
Yeah.
I need to move strike that.
The ruling objection is that sustained and you're to disregard the immediate last comment made by counsel. Go ahead.
Thank you, Your Honor. John, may I proceed?
Oh, yeah.
All right, you will see conclusions drawn by the plaintiff rely on speculation and motion and not fact. And what I mean by that is when it comes to damages, we anticipate, based upon the discoveries that presented in this case, that we'll have to challenge plaintiffs' inflated claims that don't match up to the documented fact. And I anticipate, and this is just one example of damages we believe that plaintiffs will seek is that Ms. Echevarria is going to make a claim, I anticipate $250,000 that she can no longer work. We'll present evidence there's not a single medical provider who supported that and ultimately get her to admit that was her decision to stop working. Plaintiff will ask you to hold somebody accountable. You did it in opening. Well, as you know, Zaon was held accountable. He went to jail. He was placed on probation. Didn't walk away, context of no accountability. And apparently wants additional accountability of $25 to $35 million. But accountability as it relates to my client, Mr. Collins, must be made on proof, not assumptions. We are confident that once you hear all of the evidence, you'll find that Mr. Collins, my client, is not legally responsible for the tragic accident. And that damage sought are unjustified. Justice, ladies and gentlemen, is served after all the evidence is presented for your careful consideration. And it's only at that point that y'all can render a verdict based upon reason and fairness and not an emotionally driven demand for tens of millions of dollars. Ladies and gentlemen, thank you for your attention.
Okay. Ladies and gentlemen, at this time, I'm gonna release you for the evening. But I just want to talk to council really quickly, before I let you go to make sure I've got the correct time for when we're gonna start with, witnesses, when plaintiff's counsel is prepared to start with witnesses tomorrow. So can I just have council approach, please, quickly? Okay, ladies and gentlemen, I'm gonna read you the instruction and then I'm going to release you for the evening with instructions. So please come back at 9:30 tomorrow. And if there's anything that happens where you're running late, just call the marshal to let him know so that he can let us know. We will do our best to get you started shortly after you get here. Believe it or not, this actually is moving at a decent clip. I know it probably doesn't feel like it from your perspective at all, but we're moving at a good pace. So, I'm releasing for the evening and you're instructed not to talk with each other with anyone else about any subject or issue connected with this trial. You're not to read, watch, or listen to any report or commentary on the trial by any person connected with this case or by any media of information, including without limitation, newspapers, television, internet, radio. You're not to conduct any research on your own relating to this case, such as consulting dictionaries, using the internet, or using reference materials. You're not to conduct any investigation, test any theory of the case, recreate an aspect of the case, or in any other way investigate or learn about the case on your own. You're not to talk with others, text others, tweet others, Google issues, or conduct any other kind of book or computer research with regard to any issue, party, witness, or attorney involved in the case. You're not to form or express an opinion on any subject connected with the trial until the case is finally submitted to you. The plan for tomorrow is getting you started as soon as we get here. We will do a short morning break, like probably a 15-minute, maybe 20, and then we'll do a lunch break. I will give you at least 45 minutes. If someone thinks they need more than that, let my marshal know and he will let me know. But otherwise, we'll plan for a 45-minute lunch break. And then we'll have an evening break and then we will release you for the evening, probably shortly. Plan to be here until shortly before 5. Okay, with that being said, thank you very much. We'll see you tomorrow at 9:30.
All rise for the jury. Ladies and gentlemen, please.
Okay, everyone can be seated. We are outside the presence. Does anyone need a break before we get going?
you are.
Yeah, are you guys okay?
No, you're.
Hard out at 5:15. Okay, well, we should all have a hard out just before 5, but thank you for letting me know. We're not staying after 5. If you guys need to make any kind of record that goes past 5, then I'll see you at 9 o'clock in the morning. Okay, so let's talk records. Maybe the proper way to do this, or so that we can get everything. Let's talk first about any objections that were immediately made, and then let's work our way backwards to the defense's opening. So anybody want to make a record as any of the objections that were just made, if they feel like they don't have a proper record? And I'm talking about the objections that were made during Mr. Johnson's opening, anything.
I don't think we need to make further records on any objections that were not sustained, and the objections that were sustained, I don't think we need further record on. So I think we're good from our side, Your Honor.
Okay, so no additional record. Do you guys want to make any additional record on any of the objections made during your opening statement, Mr. Johnson?
No, Your Honor, thank you.
Okay, so now let's talk about, and sorry to work backwards, but I wanted the ones that were freshest in my mind to go first. Especially because I have paper to actually confirm the ones about Ms. Zinna's opening. So let's talk about Ms. Zinna's opening. Does anybody want to make additional record regarding any of the objections and the rulings on the same pertaining to Ms. Zinna's opening, either while she was doing her opening, so the objections made in the moment, or any of the objections made and rulings related to the same on the slides?
Yeah, just additional objection on, or additional record, I'm sorry, Your Honor, on the not convicted of DUI. We still think that's irrelevant. It's prejudicial. It's confusing the jury because the standard's different. And we think it could tarnish the jury's ability to weigh the evidence based on the standard in a civil case.
Okay. Do you guys want to say anything about that?
I don't mean to rehash what I said before. However, Dr. Kelly is their retained expert in this matter. He was the toxicologist for the criminal grand jury. He has testimony under oath regarding those findings that could be relevant for impeachment purposes. And there is no rule or statute that would prohibit us from discussing, especially in the face that the criminal convictions are being introduced into evidence. Zaon's history with what he wasn't charged with, especially in light of the punitive damages claim related to the marijuana charge. So I understand that the burdens of proof are different, clear and convincing evidence versus reasonable doubt. The jury will hear the difference between those two standards and be able to make their decision as to whether or not plaintiffs have met the burden of clear and convincing evidence in this case.
Just last thing, Your Honor, the clear and convincing evidence only applies to the punitives. The marijuana is also, we also have testimony that he was intoxicated and that impacted his ability to drive safely. That would be under the preponderance of the evidence standard or fault for the accident, Your Honor. So just want to make sure we're clear on that. So
Okay, any confusion here, I think, can be remedied with clear instructions at a later date, at least at this stage. So if someone does not believe that we have instructions that remedy this, propose some additional ones. And I don't mean in this exact moment, but bring them to the other side, see if they'll stipulate. If they won't stipulate, you can always present it.
understood. The only other record I wanted to make is the accepting responsibility. I think they're confusing the issues between the criminal case and the civil case. Pleading guilty in a criminal case is different than accepting responsibility for the crash in this case. They're two separate things. I think they skewed the two in opening to the jury, making it look like I was misstating or misrepresenting the responsibility acceptance. They've never stipulated liability. They've never admitted liability in this case. They've always maintained he's not at fault and there's comparative negligence. I don't know where I think that's a big problem, Your Honor, because it reflects, I think they used it to reflect on my credibility, make it look like I'm misstating something and I'm not, because the answer to the complaint was never amended. They never admitted liability in the joint pretrial memo. That's the time to waive affirmative defenses. They never did so. Pleading guilty in a criminal case and accepting responsibility in this case are two completely separate things, Your Honor.
Okay, are you making an argument that their lack of admission in this case is causing or has caused your clients additional grief?
Absolutely, Your Honor.
Okay, so response.
Yes, Your Honor. Counsel's statement in opening was that Zaon has never accepted responsibility for his actions. He did not clarify. He just said Zaon has never accepted responsibility. Those were his words. If he is now upset that he didn't make that clarification, and I was able to say, you introduced his criminal convictions, that is obviously an acceptance of responsibility. You threw them up on the screen. They're there. That by their very nature, their acceptance of responsibility, it's fair game. Not only that, and just for the record, so as we're talking about stipulations as to liability,
Okay.
I attempted to have these discussions with Mr. Ladah, which I don't believe that are appropriate for this court to even entertain. So I don't know why Mr. Ladah is bringing this up. Mr. Ladah actually refused to even allow me to do any of that. So to argue now that, well, we've never stipulated to liability, then when he would not entertain those discussions, I don't understand how that would be relevant.
Okay, I
His
didn't
words
hear a
were what they
stipulation
were.
to liability just now, though. At least not in what Mr. Johnson got up and said. Is there like admission of liability for this accident?
So I
am I
said
missing?
we are taking responsibility for our share of the accident. We believe there is still comparative fault. We are
Okay.
taking responsibility for our share of the accident.
And if I understand, plaintiff is claiming that that position or their take on that position is causing their clients additional grief and emotional turmoil, right?
Correct.
Okay, so I think this was fair game for opening.
Thank you.
Anything else? Yeah, of course.
Briefly.
Go ahead.
The first thing is to correct the record. Defense counsel said she might stipulate to liability. She claimed she was going to send over a stipulation. She never sent over a stipulation. I sent over a stipulation to Francis a long time ago. He said he was likely going to agree. He needed to get authority to agree. He said, I'll probably sign it. And then he never got back to us. He was off the case. Miss Zinna here never sent me a stipulation, even though she claimed she was going to. Never received one. So I don't know where her claiming there was an offer to stipulate liability. That did not exist. Never happened. As far as
Well, no, I didn't hear it. I heard her saying, and maybe I'm wrong, that her client, Zaon, is okay to take responsibility for what he believes is his share of the accident. I don't know what that is yet, because I haven't heard that from anybody's mouth, right? I'm correct that there
That's
wasn't a
correct, Josh.
percentage given, but I'm assuming at some point during this thing, she's gonna, or in the closing, she's gonna suggest a percentage. So that's what I'm hearing.
I understand, and the problem is, in order to, you can amend your complaint and do that and admit partial fault.
Okay.
And still assert comparative negligence. They never did that. They deny the allegations that he was fault of the crash, and they never amended their complaint, and they never changed anything with the joint pretrial memo. So I don't know how them claiming they're
Okay.
he has already admitted, or sorry, you're understanding right?
No, I mean, here's the thing. In opening, you can say things. I don't want to call them wrong, but you can say things the other side thinks are wrong. You can. And then the other side gets to put on their case and say in their closing how wrong you were in your opening. That's part of the deal. So if the issue and the objections are based upon the fact that they're saying things that are going to be proven wrong at trial, you can do that in your opening. As long as you got a good faith belief that that's going to be, that you're going to be able to prove that at trial. Maybe you won't end up proving that, and that's where that's going to go. So if the objection is that, well, they can't prove this, or no, they're not going to do that, you get to use it against them later. Anything else?
Not on that topic, Your Honor.
Okay. You guys want to say anything?
No, Your Honor.
Okay. Anything on any other topic someone wants to get on there, or it feels like they haven't been able to flesh out?
Some logistics more than anything, Judge. Tomorrow, so it sounds like Zaon will be appearing via Zoom. Your Honor's instruction, I believe, was that any witnesses testifying via Zoom need to be provided whatever materials might be shown during their testimony.
Okay.
So
By the person presenting them via Zoom. So if you want to put him on via Zoom, does he have everything? Because he's the party, so they can't communicate with him.
Yes, so they sent me a list of things that they wanted to use. I asked them to just make sure they send me the document, so I'm conveying the correct information and I'm not making an incorrect assumption, and then we don't have it. So that I responded to that email. I will also say for the record that we are doing our best to see if Zaon can catch a flight here to be here. So if that changes, we will let you know. But as of right now, he is appearing via Zoom. If counsel wants to send me the documents, I am happy to pass those over to Zaon.
I will do my best to send the documents tonight. Maybe we just need a couple hours when we get back to the office to figure out exactly what we need to send. Because now a few things have changed based on the opening statements, Your Honor.
Well, doesn't he just have these books?
Well, he also needs to have the complaint and the answer now that with this issue that's come up, so.
Oh, well, that's a quick email, I hope.
Right.
And also, Judge, there may be clips from body worn camera and so forth that we may want to use and ask questions about. If so, can
Those
we?
clips are not in these books?
Well, they are, but I don't know how he would have to plug it in, and what we could do is just put it on the screen in the Zoom so he can see it.
He can see the screen, but you're not gonna see him while he sees the screen.
We
No
understand.
split screen ability.
So
We just don't need to play them contemporaneously.
yeah, we don't have to do it contemporaneous. So what we would do is we would show him the video, take it down and say, did you see that video? And ask him a question. Does that make sense?
Yes.
Is that gonna be an issue, Your Honor?
You can, I mean, it's not gonna be an issue for me.
These are clips that are pre-admitted, Judge.
Are you, is there, what would be the issue? I'm sorry, what am I missing?
No issue. It's just I've had some judges in the past, hate to bring up other departments,
No,
but
it's fine.
I've
Just
had-
don't say the name of the judge or the
I won't.
department. Just tell me what the issue
I've
is.
had some judges in the past that didn't want us to put things up on the Zoom screen. They only wanted the witness on the Zoom screen at all times. And that confused us a little bit.
I mean, look, it's your case. So, I mean, I'm not gonna control what's on the screen. If you want to show a video on the screen, I don't know what your other option would be. What did they do? Did you send it to them and then they had to like watch it on their phone or something?
I had to basically abandon showing the witness documents.
No, I mean, the problem is gonna be that we have no split screen ability. So you might want to, I mean, he's a college student. He doesn't have a computer where he can be emailed the video and then he can like just click a button on the screen because you guys have sent it to him.
Well, if he has the,
Usually-
I mean, if
I'm not
he
trying to like stereotype here, but
No.
I mean, I find that younger people are usually even better with technology than most of us.
If he has the exhibits, then I'm assuming he could just plug the thing in and watch it himself, and we can tell him what timestamps to go to.
Yeah. I mean, what's the chance he's gonna be on a plane? I'm assuming he doesn't have final Saturday and Sunday, right?
He does not, so that's what he finishes his last final today,
Okay.
but he doesn't finish that until 9 o'clock tonight. Is the problem.
What time is the flight out?
So they have not booked it yet and I don't know if that has changed in the time we've been in court.
Okay,
So I don't know, and that's why when we were at the bench, I wasn't sure. I was like, well, 10 o'clock, because if he catches an early flight, I'm doing my best to get him here. I don't know if the flight times are gonna line up.
it's like you can get a flight and maybe you guys can get him actually physically here in the afternoon. Are you sure you don't want to talk to her about that possibility? And then I mean, I don't, look, you control how you do the videos, okay? I don't mind however you want to do it, okay? I'm gonna let you show the video you want to show, but the problem is we are limited and maybe some of you guys send representatives from your office to bench bar and say, we want a split screen, we want a split screen, we want a split screen. Come on, how do we get this? And start voicing concerns over and over and over again. It'll probably eventually hit, especially if we find some way to pay for it. But maybe this is something you guys discuss. Okay, let's just talk. The plan for tomorrow is Zaon, and then who's next?
Sam Terry,
Sam Terry, and you're ready for this one too, right?
Correct.
Okay, and then who else?
and
Is that
then
it?
Robin Lee is an witness who was at the scene. She'll be here in person. And
Okay, so tomorrow is
We're like-
Zaon, and maybe you guys will talk about, maybe it makes sense to have him be in the afternoon instead. If you can have him here in person, just a thought, but
For us, it's just he needs to go before Sam Terry.
okay. Sam Terry, and what time is the plan for Sam Terry? Afternoon?
we've told him to be ready for as early as 11 a.m. It's because we don't know necessarily how much the defense is going to go into it with Mr. Collins, or whether they're going to do the bulk of his testimony now, whether they're going to recall him and reserve that for.
You guys haven't let them know if you're gonna do your testimony that tomorrow or not?
I'm sorry.
For Zayon, if you're gonna.
No, I will not. I might ask him a couple of questions if it's needed, but no, we'll recall him.
You want to recall?
So for that
Okay.
reason, Judge, we're having Sam Terry available as early as 11 a.m., which doesn't sound like
Okay,
it sounds like that'll be if there's any gap in between, it'll be minimal.
okay,
And then I believe we're lining up Miss Lee for first thing in the afternoon.
okay. What's Miss Lee's first name?
Robin
Robin Lee. And how long do you expect Robin Lee to go?
on direct, Judge, 45 minutes. 30 minutes to an hour, let's say that.
And remind me what is Miss Lee's role here?
She was at the scene. She was a
Scene witness?
Yes, Judge.
Okay. And then who else do we have for tomorrow, if anybody?
Marie Echevarria is the decedent's sister.
Okay.
Now, she lives in the Bronx. We had scheduled to have her come out here, to fly out here. We just got word that for medical reasons, she was not able to.
Okay.
So I hate to put my colleagues here on the spot to see whether there's a stipulation for her to appear via Zoom tomorrow afternoon, which would help with her flexibility, because we could basically plug her in wherever.
Oh, I have no objection to that.
Okay,
The plan will be for her to go last, Judge, after Robin Lee. If for whatever reason we need some to shuffle them
fill the
around.
space.
Yeah.
okay. So we have all these 4 people on deck for tomorrow. With the idea that they might be shuffled a little bit time-wise. And Maria Echevarria, if you guys are putting her on via Zoom, she has all this stuff, if she's gonna need any of it, and by this stuff, I mean the exhibit books.
We don't anticipate her needing anything, and if she is going to, we will provide it and make sure we notify our.
We always can give them an instruction, by the way, that witnesses have been called out of order, and I think it makes sense to call some of these people out of order to get this done. Especially because I think this jury is gonna prefer to be out of here a couple days earlier rather than wait for a specific order. And take days later, especially because I imagine you're gonna both take your closings and pull the parts you want and create the whole story for them all over again in whatever order you think it makes the most sense. I'm not forcing you to call in a certain order, but just keep that in mind, that it might make sense to call out of order to get things done, or to get things done in a way that makes more sense to the jury, because Zoom might be difficult with a few people.
Judge, we're confident we can get these 4 witnesses in tomorrow in the order that we've outlined, and that'll well position us to finish next week as we've laid out.
I'll be here 9:15 tomorrow if anybody wants. Oh, actually, hold on. Any additional record for today before we break?
No, Your Honor.
Oh, Your Honor.
Okay, I'll be here 9:15 tomorrow if anybody wants to go on the record with anything outside of the presence. Otherwise, I will see you guys at 9:30. I'll come out or my staff will let you know when we have all the jurors here. And we'll just go ahead and get started with the first witness who, right now we're planning for it to be Zaon, right?
Yes.
Okay. Thank you guys. Have a good afternoon.
Thank you.